So the courts actually set the parameters for you in the classroom and your rights as teachers and the rights of students. So in this video, I'm going to highlight some of the main legal cases that have happened over time that provide you some more information on those parameters. So in the first one, in Tinker versus Des Moines, basically what happened in Tinker versus Des Moines is that students were coming to school to protest the Vietnam War. And so in order to protest, they wore black armbands. And some teachers felt like that was really disrupting the classroom environment with their peaceful protest. So the issue in this case is whether schools can censor nonviolent student speech without violating the students' First Amendment rights. So again, in this case, the students wanted to wear the black armbands to protest the Vietnam War. The teachers were saying it was disruptive and therefore could not wear the armbands, and did not allow them to wear the armbands to school. And so the students filed a lawsuit. And so the issue again at hand is, can you, as a school official, as a teacher, as a future administrator, can you censor nonviolent student speech? And this is what one of the judges said. They said, you know, teachers and students do not shed your constitutional rights to freedom of speech and expression at the schoolhouse gate. So what they're trying to determine is, just because you're entering school grounds doesn't mean that you stop having an opinion, that you're not free to discuss or express those opinions to other people. However, they did put some parameters on those that we'll talk about in future court cases. So in this particular case, the Tinker standard, what the courts determined is, first off, they look at, is it a substantial disruption to the school environment? And in this case, the black armbands were not a substantial disruption to the school environment. Since it was peaceful, since it was nonviolent, since it wasn't correcting anything else, it was simply wearing a black armband. It was not considered a substantial disruption. And then also the second thing they look at is it an invasion of the other people's rights? So if you are in fact invading the rights of others, then we would have the right as teachers or administrators to censor your speech. And again, in this case, for the black armbands, they weren't materially disruptive and they weren't invading the rights of others. So the courts actually upheld the students' right to do the peaceful protest. In Hazelwood v. Kuhlmeier, it was a slightly different issue. So in this particular issue, it was students who are writing in a school newspaper. And the items that they were writing about in the school newspaper were deemed inappropriate by the school officials. And so therefore, they were pulled from the school newspaper and censored. So again, the students sued the school to say they violated their First Amendment rights. So the issue in this case is whether or not the school did violate the First Amendment rights by eliminating the articles from the school newspaper. And so in this particular case, the Hazelwood standard, one, you have to on top of the Tinker standard. So let me go back and say that. So still we have to look at the Tinker standard. Was it disruptive? Did it invade the rights of others? And then the Hazelwood standard actually offered up two more things. First, we have to look at, is it happening in a public forum? Is it a school-sponsored club or activity? And in this particular case, the school newspaper is a public forum. It is a mass audience that lots of people would be exposed to. And in this case, censoring it doesn't serve a legitimate pedagogical purpose. So is there a very good teaching, learning reason that you're censoring that material? Does it serve a pedagogical purpose? So in this particular case, they were allowed to pull those articles because it was a school-sponsored activity and because they did have a pedagogical reason to pull it. The courts also set some additional standards saying if it's poorly written, if there's vulgar or lewd talk, if it's prejudiced or biased, if it talks about sensitive topics, which again can be kind of subjective, or if it's topics not suited for an immature audience, which again is kind of subjective, then the school officials, teachers, administrators do have the right to censor your speech inside school newspapers, inside school essays, debates, anything that happens in that kind of school public forum. Teachers do have a right to censor the speech. And this next case, Lee versus Wiseman, it has to do with the religious aspect. So what happened in this case is they invited a clergyman to speak at the invocation to a graduation. And they had the students stand up out of respect to this clergy member. And in fact, the clergy member that they chose was non-denominational, so it wasn't any particular religion that was being pushed or proselytized. So it was just kind of a general kind of spiritual kind of invocation. So the issue here is whether or not you can invite a clergy member of any kind, and in this particular case it was a rabbi, to give an invocation or a benediction at the graduation ceremony without violating the Establishment Clause. And the Establishment Clause of the First Amendment has to do with establishing religion or promoting of a certain religion. And so what happened in this case is the schools were trying to say, you know what, the teenager didn't have to come. She didn't have to stand. Nobody forced her to pay her respects. And so the courts were kind of saying, you know, that's pretty ridiculous. To say that a teenage student has a real choice not to attend her high school graduation is formalistic in the extreme. So they were saying that just by the pure fact that it was a graduation ceremony, which is kind of a rite of passage, that it was a school-sponsored activity, that the peer pressure that was around for her to stand kind of did provide that coercive act for her to stand up when the rabbi gave the invocation. So the original kind of religion kind of law case in the Lemon test is the schools kind of have to ask three questions. One is the purpose of this particular religious act. Is it secular? Does it serve a secular purpose? And in this particular case, it wasn't. It was an invocation that was delivered by a rabbi. Second, is the effect neutral with respect to religion? And in this case, the schools thought that they were being okay because they weren't promoting any kind of specific religion. They weren't advancing or inhibiting. But they were saying just by the nature of it being a clergy member that it was not in fact neutral with respect to religion. Third, you have to ask, is there no excessive entanglement with religion or religion with government? So does it look like it's all wrapped up together and not separated out? Then there were two more things that they added as a result of this Lee versus Wiseman case. One is an absence of coercive effect. And in this particular case, they were saying just by the nature of being a teenager at a graduation ceremony, it was very coercive. It made her feel like she had to be involved. And then the second thing is government can't endorse a religion. So you really can't, as a school body, which is a government institute, endorse any kind of religion in any kind of way. And this other kind of religious-based case is Santa Fe v. Doe. So what happened in this case is that students voted that they wanted prayer before a football game. And in fact, they had students who were voted to lead that prayer. And so each week it kind of rotated among students on who would lead the prayer before the football game. So again, it's not necessarily that it was at school per se. It was voluntary. It was student-led. And so the schools felt like they were within their bounds because it was student-initiated and student-led, that it was going to be okay. And so there's the issue. Whether or not student-led and student-initiated prayer to football game violates the Establishment Clause. So again, the schools were saying, you know what, hey, it wasn't us. We're not the ones who promoted this. It was student-led. It was student-established. It was student-initiated. Therefore, really, there shouldn't be an issue. Again, the schools had the courts had a big problem with this by saying that, it was still public speech authorized by the school government institution taking place on government property at a government-sponsored activity. So it was still at a school event on school property, school-sponsored, because they allowed the students to initiate that. The other kind of thing that they really got into is that even though students voted on it, it's still going to be the majority kind of way. So the minority of the students maybe who didn't want that or who maybe are of a different religion would never be represented at that football game. So indeed, you cannot do prayer before football games at that kind of public event. In New Jersey versus TLO, this has to do with students' rights as far as search and seizure. So the student was caught smoking in the bathroom. She got turned in and looking to find the cigarettes, they actually found marijuana rolling papers, and so she was suspended. And so the student fought back saying, they really didn't have a right to search her purse. So the issue is whether or not a public school official can search a student's belongings without violating his or her 4th and 14th Amendment rights. 4th rights is search and seizure, and 14th Amendment rights being her due process. So here's kind of what the courts have said about search and seizure of a student's belongings. So you kind of have to strike a balance between the student's right to privacy and the school's legitimate need to protect the other students in school and to maintain order. So although students do have a right to privacy, at the same time, you have a right to protect everybody else's safety and the order within inside the school. So although police officers need to have probable cause